Hello, my name is James Partridge, and I'm a barrister specialising in commercial and employment law at 2 Temple Gardens. This is the latest of 2 Temple Gardens' monthly employment law updates, and if you haven't watched the other updates already, I encourage you to do so. My talk is called Spot the Employer, Untangling Employment Arrangements, and addresses the issue which arises more than you would think of who is the true employer for the purposes of a claim under the Employment Rights Act. Firstly, why does this issue arise? Well, it most often arises when one is dealing with relatively complex company structures such that it may not be instantly clear who the employee's actual employer is. This becomes particularly significant either on issues of jurisdiction, where some of the company structure may be offshore, and on issues of insolvency, where it may transpire that the company identified as the employer in the written contract has no actual assets to meet any judgment obtained against it. As for the structure of my talk, it will be in 3 brief parts. First, I will address a preliminary question of how many employers may an employee actually have. Second, I will address the most recent Employment Appeal Tribunal authority setting out the test for identifying the true employer. That is the case of Clark and HARNEY, WESTWOOD and RIEGELS. Third, to make up for the fact that Clark is over a year old, and this is an update, I will look into the future and discuss how the test in Clark may be modified in light of the Supreme Court Uber judgment. So how many employers can you have? I will deal with this issue shortly for the purposes of this update, but the answer is not as straightforward as you might think. There is old common law authority for the proposition that a servant cannot have 2 masters, and this principle is still recognised in employment cases to date. However, 2 relatively recent Employment Appeal Tribunal authorities cited with approval the 2006 judgment of Employment Judge Clark in a case called Cairns and Vistian UK Limited, where, while recognising the aforementioned common law principle, Judge Clark envisaged that an employee may have different employers for different jobs, or the contract of employment itself may be severable into different parts. I have not found a case which addresses such problems as which employer is then liable for the purposes of an unfair dismissal claim, or by way of further example, which employer has consultation obligations in a redundancy situation. However, Judge Clark's conclusion that these problems weren't insurmountable and required further consideration were approved in Patel and McTeer, where, perhaps disappointingly, at least in McTeer, the only further comment was it's going to depend on the facts of the case. Clark is a judgment of Mr. Justice Chowdhury, and the central issue before him was the true identity of the claimant's employer. The claimant was an employed barrister in the Cayman Islands who brought claims against her firm in England as 3 of the partners resided in the UK, and she therefore had jurisdiction in her case under the Brussels Recast Directive. The first-tier tribunal found that she wasn't employed by the defendant with whom she had contracted, but rather a different Cayman entity who had applied and obtained her work permit on the defendant's behalf. The result of the first-tier tribunal's decision was that the English Employment Tribunal had no jurisdiction over the claimant's claims. Mr. Justice Chowdhury, perhaps unsurprisingly, overturned the first instance decision in circumstances where the employment contract identified the defendant as the employer, and in practice, the defendant always acted as her employer. In so doing, Mr. Justice Chowdhury carried out a review of previous relevant case law. In this regard, Mr. Justice Chowdhury cited, amongst other cases, Dynasystems for Trade and General Consulting and Moseley. In that case, the Employment Appeal Tribunal found that the true employer was an entity other than the entity identified in the contract due to, quote, a seamless stream of events, end quote, from the outset, which showed that the true agreement was other than that was written in the contract. Mr. Justice Chowdhury significantly noted that this was an application of the principles established in the 2011 Supreme Court case of AutoCleanse Limited in Belcher, which concerned whether the claimant was a worker under the working time regulations. Mr. Justice Chowdhury considered applicable to the case before him the observations of Lord Clark in AutoCleanse that employment contracts are different from other commercial contracts given the disparity in bargaining power. and that the true nature of the agreement will often have to be gleaned from all the circumstances of the case, of which the written agreement is only part. At paragraph 52 of his judgment, Mr. Justice Chowdhury gave future guidance on the question of identifying the correct employer. I will not quote this paragraph in full. It is set out in the slide. However, I wish to make two key points from this guidance. First, consistent with Dynasystems and AutoCleanse, the guidance provides that the tribunal is to inquire into the true intention of the parties as to the identity of the employer. If the parties acted throughout on the basis that a certain entity was the real employer, then this may amount to evidence that the agreement from the outset was that that entity was the employer, irrespective of the terms of the written employment contract. The second point I wish to make is that although the guidance makes clear that the written contract is not determinative, Mr. Justice Chowdhury held that the written contract will be the starting point of the analysis before the tribunal should go on to ascertain whether facts point to a different outcome as to the parties' intentions. As things stand, the case of Clark is the most up-to-date guidance specifically addressing the issue of who is the true employer. However, looking into the future, I believe that the tribunal may place a slightly different emphasis on the role of the written contract than that set out in the guidance in Clark. The reason for this is the 2021 Supreme Court case of Uber and Islam. Like AutoCleanse, Uber is a case which concerned the definition of a worker, this time for the purposes of the Employment Rights Act. In the judgment of Lord Leggett, giving the only judgment of the court, he observed that critical to the decision in AutoCleanse is that the rights being asserted were not contractual rights, but were created by legislation. And accordingly, the primary question was one of statutory interpretation, not contractual interpretation. Lord Leggett concluded that it would be inconsistent with the purpose of the legislation to treat the terms of a written contract as the starting point in determining whether an individual falls within the definition of a worker, and to do so would, quote, reinstate the mischief which the legislation was enacted to prevent, end quote. In my view, this logic applies to the question of ascertaining the true identity of the employer, just as it does to ascertaining the true nature of the claimant, i.e. whether the claimant is a worker or an employee or otherwise. The Employment Rights Act gives rights to employees as defined under the Act, enforceable against their employers as defined under the Act. It follows, in my view, that consistent with the Uber judgment, the starting point of identifying the employer for an Employment Rights Act claim, contrary to the guidance given in Clark, is not the contract, which is of course highly relevant, the written contract, but rather from the outset, the tribunal should consider the reality of the situation in the round, adopting the purposive approach to ascertaining whether the parties fall within the definition of employee and employer as intended under the Employment Rights Act. In this way, while the practical effect may be small, I think that the Uber judgment means that a slightly different gloss should be given to the Clark guidance when the question of who the correct employer is next falls for consideration in the tribunal. Whether this is correct, however, remains to be seen. I note finally that the significance of the Uber judgment was recently underscored in the Court of Appeal case of Sedgebull and Roderick Stental Limited. This is another worker status case, but I noted, as in Sedgebull, the Court of Appeal observed, consistent with the 2017 Court of Appeal Pimlico Plumbers judgment, that the presence or otherwise of an unfettered right of substitution is particularly relevant to the question of whether an agreement is for personal service. However, significantly, the Court of Appeal went on to say that it was arguable post-Uber and the focus on statutory interpretation that there may be a situation where the contract provides in terms an unfettered right of substitution, but the reality is that the predominant purpose of the agreement is for personal service, or even, perhaps, personal service need not be the predominant purpose of the agreement, provided that the true agreement was for the provision of any personal service as required by the statute. The relevance of this to this update is that it demonstrates the significance of the Uber judgment in diverting the tribunal's attention away from the written contract and to the statute. And if the written contract is taken as the starting point, certainly on the question of worker status, but also, in my view, on the question of the identity of the employer, the tribunal may be taken to have fallen into error. I hope you found this update useful. I have certainly enjoyed giving it.